for joining us. Good evening.
Good evening. You're welcome.
Okay, let's start with the top. It is a first under the 2010 Constitution. You know, as you give your initial thoughts on the process, talk to us about the entire process as enshrined in the Constitution.
Well, you see, first and foremost, the remedy of impeachment is at the highest executive level, reserved for the president and the deputy president. And the purpose of this remedy is to ensure accountability and responsibility of the holders of that office. There are three grounds upon which the removal of the president or the deputy president may be undertaken. One, if the holder of either of those offices has committed a gross violation of the Constitution. Two, if the holder of that office is suspected to have committed a crime under international law or local law. And three, for gross misconduct. The process is quite straightforward as set out in the Constitution. It is initiated in the National Assembly by a vote of not less than 2/3 of the members of the National Assembly. When that resolution is made by the National Assembly, then it is forwarded to the Speaker of the Senate. Now, the trial court for the removal of the president or the deputy president is not the National Assembly. It is the Senate. It is at the Senate that the charges that have been forwarded from the National Assembly will be investigated. And then the Senate will need to certify itself that those charges have been substantiated, they have been proved, they have been established. And then upon the charges being established, a vote will be taken, again, by not less than 2/3 of the members of the Senate. So if upon establishing the charges and upon taking a vote to a limit of 2/3 of the members of the Senate, then the holder of that office will stand impeached.
Okay, let's talk about public participation, which begins tomorrow. I mean, we have seen instances where government policies have been put on ice because of public participation. How important is this step?
Well, it is important because this is a fundamental constitutional process where the people of Kenya ought to be involved. And that requirement is imposed upon any state office, any agency or any arm of government by virtue of Article 10 of the Constitution. So it is an important process. But what must be understood, the trial of the deputy president will not be conducted by the National Assembly. So these processes are being taken as an extra measure, an extra caution. The real trial will be before the Senate.
Because, you know, majority of Kenyans are asking, can it make a difference? Going with what we've seen in the past when it comes to public participation, will it make a difference?
Of course, it will make a difference. It will give validity to the process. The gravity of the charges that the deputy president is facing cannot be overemphasized. They are serious allegations. And from the face of it, they appear to be meritorious. But the views of the people ought to be taken. And it's for that reason that the National Assembly has taken the appropriate step of availing the most available, the widest circulation of public participation so that everybody presents his or her views as far as this matter is concerned.
Okay, let's take a look at the 11 grounds that the move of the motion laid out. What are the constitutional grounds of removing? Of course, you've talked to us about that, but is there a threshold out of the 11? If the 3 are, you know, he's found guilty of 3 or 2 or even 1, then he's out.
The threshold here is much lower. And even before we interrogate the quotient of the threshold, remember the removal of the president or the deputy president is both a qualitative and quantitative exercise. Qualitative to the extent that the charges must be investigated and substantiated. And quantitative to the extent that upon substantiation of those charges, they must be voted upon with an overwhelming majority. But back to your question. Remember, what informs the presentation of these grounds and the consideration of the same is not a conviction. For instance, when we're talking about the commission of a crime under municipal law, under the laws of Kenya, There just has to be reasonable belief. There ought not to be a charge before a criminal court which the deputy president has been presented and been convicted. You understand? Same for violation of the constitution. There ought not to be a finding by a court of law that the deputy president has violated the constitution or has contravened a particular section of laws beneath the constitution. Just a belief.
Okay.
So to that extent, this threshold is one that is likely to be met if you're considering the qualitative aspect of this consideration. As to whether or not sufficient numbers would be marshaled, both at the National Assembly or at the Senate, is a different question altogether.
How long will this process take?
It's supposed to be short because the office of the Deputy President is a very important office. It is one in which we cannot entertain a lengthy trial. So as soon as a resolution is made by the National Assembly, the Speaker of the National Assembly has 2 days to notify the Speaker of the Senate. The Speaker of the Senate has 7 days within which to convene the Senate, to sit and try the matter. The Senate may designate a small number of themselves, 11 in particular, as a committee, to consider these charges, to investigate them, to substantiate them, and then present it to the full House of the Senate within 10 days. So 2 days plus 7 plus 10. It ought to be done in a period of about 20 days.
Okay. Is it a double